Okay, we're a couple of minutes past the hour, so I might get started. Hello, everyone. Good evening, good morning, good night, depending on which time zone you're in, and welcome to the latest in the International Association of Genocide Scholars book launch webinars. I'm Melanie O'Brien, the president of IAGS, and I am delighted to be able to introduce our discussant and our author for this webinar. Our discussant tonight is IAGS member Dr. Shannon Fife, who is an assistant professor of philosophy and a fellow in the Institute for Philosophy and Public Policy at George Mason University. Her previous work includes a fellowship with the Syria Justice and Accountability Center, where she advised the organization regarding best practices for collecting evidence of sexual and gender-based violence in Syria. She has also worked at the American Society of International Law's Arthur C. Helton Fellowship, where she provided legal assistance to Tanzanian officials, policymakers, and the Commission for Human Rights and Good Governance to implement national laws that promote human rights for albino persons in accordance with international legal standards. Dr. Fife has also held an internship with the International Criminal Tribunal for Rwanda's Office of the Prosecutor. Dr. Fife has also provided pro bono representation for wounded veterans applying for medical benefits, and she has spent time volunteering on death row in Tennessee. She holds both a PhD in philosophy and a JD from Vanderbilt University. As an academic, Dr. Fife's research interests are in political philosophy, ethics, and legal philosophy, with a focus on philosophy and international conflict, particularly international criminal law. Her work in this field seeks to provide a philosophical framework for defending and criticizing current practices of holding individuals legally and morally accountable for their participation in mass atrocities. She has published articles that engage with international criminal law, speech act theory, just war theory, and moral psychology, and she recently co-authored a book responding to criticisms of international criminal courts and tribunals. Dr. Fife will be in discussion with tonight's author, who is Dr. Onur Uraz. Onur is a lecturer in public international law at Hacettepe University in Turkey. His research interests center around international criminal law, particularly the legal conceptualization of the crime of genocide, human rights law, and international energy law. Dr. Uraz received his PhD in international law from Southampton University in 2020, following completing his LLM in the same field at the University of Glasgow. Dr. Uraz has been a valued member of the IAGS Resolution Committee since 2017. So it is my delight to introduce these two high-achieving IAGS members to you, and I will now hand the floor over to Shannon and Onur.
Thank you so much, Melanie. To Onur, I will start by thanking you so much for writing this book. It touches on so many things that I am personally interested in and engages with so much of the literature that I have engaged with in the past, such that I can't help but wish I had been brilliant enough to write this book myself. Many of you in the audience will undoubtedly be interested in these issues as well. I can say this is a complex yet accessible book for any non-lawyers who might be intimidated by the legal aspects, and I'm excited to get to talk to Onur about it today. So first, Onur, I was hoping that you could tell us two things. So first, what is the substantiality requirement? I know that this is an IAGS-sponsored event, but given that people work on such a wide range of topics from many different disciplines, could you explain this aspect of international criminal law and jurisprudence? And then could you tell us a little bit about how you started working on the substantiality requirement?
Now, I turn on my voice. Thank you. So I would like to thank IAGS and Melanie specifically for this opportunity. And I also, since I have the opportunity now, I would like to thank Melanie for her support over the years. And also I would like to thank to you because it was a bit of short notice to read the book, I know, but you did a brilliant job, and I know you will be brilliant in questioning the aspects of the book. So let me begin by explaining what is substantiality. As you all know, the legal definition of genocide, which was established by the Article 2 of the Genocide Convention of 1948, defines the crime as any of the 5 following acts committed with intent to destroy in whole or in part a national, ethnic, racial, or religious group as such. Now, for us, for lawyers, actually, there are 2 sides of this definition. One, what we call actus reus, which is the acts of genocide, which are those 5 acts listed in the definition. These acts are not specific to genocide. Actually, they are criminalized in domestic legal systems. They are also criminalized by the international crimes like crimes against humanity or war crimes. So what makes genocide unique in legal sense is what we call mens rea, so which is the subjective element of the crime, which is the subjective relationship between the act and the perpetrator. And this is defined as intent to destroy in whole or in part a national, ethnic, racial, or religious group as such. This is the distinctive part of genocide for lawyers. But consequently, this is the most debated part of the legal definition. Each term in the mens rea element is open to debate. So we are still debating what should be the level of intent in order to speak about the genocidal intent, whether dolus eventualis is enough, or do we need dolus specialis, etc. Or the term to destroy, which I will discuss, I hope, in a moment, is open to discussion. You know, should we understand only the physical and biological destruction, intended physical or biological destruction by the term genocidal intent, or other acts of destruction like burning books, burning buildings are also instructive to understand the extent and nature of genocidal intent, which is quite important for my subject, the substantiality requirement, because it changes everything. As it changes Srebrenica, as I will explain in a moment, I hope. So the other points of discussion, how are we going to single out the groups? What are we going to understand from nationality, ethnicity, which was a huge problem before ICTY, because in a Kayasu case, the court tried to establish an objective approach. They tried to give a specific meaning to each, term, nationality, ethnicity, race, but then it failed because in objective terms, there were no such, divergence between Tutsis and Hutus. Then Darfur Commission went completely to the other way. They tried to establish an entirely subjective approach, which was also problematic because then what's the meaning of the listing if, the perpetrator can name the group as he or she wants. And also you are giving a leeway to the perpetrator. And also the term as such is enigmatic as always. We will touch upon that. But my focus was actually the term in whole or in part, because although each scholar who works on this subject pointed out that this is quite an ambiguous term, what we are going to understand from in whole, especially from in part, the term in part. With exception of Paul Brahms, no legal scholar or any other type of scholar, as far as I know, although there's a new article from an Australian scholar, but never mind. Oh, yeah. Anyway, sorry. So, although we know and we realize that the term in part is quite enigmatic, we didn't do any, extensive research about that. So I saw this gap. And why this is important and what's substantiality, now I need to explain that. So in order to establish genocidal intent, one, we need to have intent to destroy. That intention should be directed against a national, racial, ethnic, or religious group, as such as a group. And that intention can be directed against towards entire group or a part of the group. However, the problem is that even I, a part of a group, or Shannon is a part of the American nation, probably American ethnicity, I don't know. I'm attributing some qualities to you now, but sorry. So here is the problem. If I try to destroy Shannon with intention to destroy, because you are a part of the American nation. So if you are a part of the American nation, and if I intend to destroy Shannon, because of her nationality. So, does it constitute genocide? So it makes no sense because genocide sociologically is no such term, as you all know. So the international courts and tribunals developed their jurisprudence in a direction to, add a qualification to this term. And they say we need to read this term as in whole or in substantial part. Now, if your intention is a genocidal intention, it needs to be directed towards whole group or a substantial part of it. But as you may expect, now we are discussing what should we understand from substantial part. So there are three theories or three approaches established by the international courts and tribunals. One is quantitative approach, one is qualitative approach, and the other the geographical approach. The quantitative approach says that numbers are what matters. So if you are targeting a large chunk of the group, whether as a percentage or in absolute terms, it may qualify as substantial. Qualitative approach, which was prominent in Srebrenica, adjudications, it says a smaller part may be qualified as substantial if it is important for the entirety of the group. And finally, geographical approach says that a substantial part may be determined according to the geographical distinctiveness of the targeted part. Once again, this was important in the Srebrenica adjudication and decisions. However, each of these terms are problematic in itself because, for instance, okay, we are talking about a quantitative approach, but what percentage of a group qualifies as substantial? 1%, 10%, 5%, it's all subjective. And, if I am a member of a group of 10,000 people, 1% of my group is not that substantial in absolute terms. But if you are talking about like Chinese nation or Indian nation, it would be a catastrophe, a human disaster targeting 1% of those, populations. So these are all subjective. Similarly, qualitative approach is subjective in itself because who decides which part of the group is qualitatively important? And this is a kind of an elitist approach because in Whittaker report in 1986, he was talking, it was a report by Benjamin Whittaker to the United Nations about the legal elements of genocide. And he was talking about, political leadership, educated people, they can be considered as qualitatively significant, but then this is an elitist kind of approach to the issue. And also we cannot predict the future. Maybe now I am an unimportant person or my family or whatever, but in 10 years, 20 years we will be significant, and some now significant people will do some harm to the community. So this is all speculative in the end. And geographical approach does not explain first of all, how small or how big should be that geographical area. A village is enough for a part to qualify substantial, or do we need a city, district, what is the limit? And the second thing is, what is the moral distinctiveness? What is the difference of targeting 40,000 people randomly and targeting, not randomly, but 40,000, let's say, American people, and 40,000 American people in a particular district of Maryland? What's the moral difference between them? I mean, why the latter one is morally worse than the former? So this was one of the questions that we need to ask. So these are all ambiguous, elements about the jurisprudential or jurisprudential, solutions that are offered by the courts and tribunals. And this was a starting point for me because I felt a bit disturbed about this. And I need to pay some respect to the great Paul Berens from Edinburgh University because I borrowed the idea from him. He, get my attention to this subject and this ambiguity. But then when I get involved with this, I realized that there's more into it because, and I will give the word back to you. But before that, I need to say this, because first I approached the issue like any other lawyer, and I try to figure out all the things with a doctrinal approach, which is an approach taken by many lawyers, which is an approach that deals with things from purely legalistic point of view. So figuring out things from within the law, rather than, referring to philosophy or any kind of sociological assessments. And then I realized, actually, we are not doing that. Each different approaches offered for the term substantiality actually build on a different philosophical presumption about the nature of groups and group destruction. So that was fascinating for me. And I went a totally different direction, even from Paul Behrens himself, because he's quite a doctrinal lawyer. And that was quite fascinating for me. So let me give you the word back. So.
Thank you. That is so helpful and interesting, and to give us kind of a shape of the landscape in terms of the jurisprudence and in terms of how you got interested. And you gave me a perfect segue to get into the next thing I want to talk about, which is one of the other disciplines that you use that really grounds your approach to why you think that we should have a different way of thinking about the substantiality requirement. And in particular, that's coming from what you think is important about retaining this category, this particular crime of genocide. So I wanted to dig in on some of these kind of metaphysical questions. I know my students hate it when I come in and say we're doing metaphysics, but I agree with you that you have to do these, answer these ontological questions before you can kind of set up the doctrine, right? So the third chapter of your book considers individualist or nominalist views of victim groups, as well as collectivist views of victim groups, especially Lemkin's. And so you argue that individualist views, you claim that they leave out what we think is distinctive about the harm to groups as such about genocide. So I was hoping that you could say a little bit more about the individualist understanding of a victim group and the collectivist understanding, how each of these might align or not align with our intuitions, and then what you think is ultimately lacking. You come down in favor of a collectivist view, but you want to distinguish your view from Lemkin. So I think this social ontology will be really interesting to people today.
Yeah, that's a great question. And also, I took some lead from your great friend, let me call friend, Larry May, because he was both a philosopher and lawyer, and he was, as far as I know, the first person who noticed this correlation between our social ontological presumptions about groups and group destruction and how we construct law, basically. So let me begin by saying that what we understand from the group, and connectedly what we understand from the group destruction, actually determines our entire understanding of genocide. I can easily say that, because if group to you, philosophically and sociologically, is kind of an assemblage of people, there's no distinct value inherent to the group, separate from the constituents which form the group, then you are an individualist, and you are saying that harm of genocide is actually a harm directed towards individuals, towards victims. However, here is the problem. Crimes against humanity aims to protect the very similar thing, a collective attack against individuals. So what genocide historically claims is that we are protecting the group as such, not only individuals, but that, distinct entity which exists beyond and above, let's say for now, beyond and above the constituents. So it is bigger than some of its parts. Basically, this is the classical, explanation to it. But when we look at it historically, first-grade legal scholars like Peter Drost or Nehemiah, I always mispronounce his name, Nehemiah Robinson, they are actually individualistic scholars, because they are defining the group. And by the way, I need to point out that lawyers are not really explicit about their ontological position. We are picking up some bits and parts from their writings and their general approaches. But interestingly, both Drost and Robinson were quite straightforward about that. For instance, Drost was saying that group is merely a number of persons contemplated as a distinct aggregate or assemblage forms the object of the protection under the Genocide Convention. A similar kind of approach was taken by Robinson. So they were basically saying that when we say group, it is people who have the same, qualities, let's say. So there's nothing more than individuals in the group. So when you say that, then the destruction is all about individuals. You cannot destruct the group if you are not destructing individuals, because group and individuals are now equal to each other. So collective of individuals, assemblage of individuals. And which means then you need to understand from what you need to understand from the term to destroy is physical or biological destruction, because this is the only way, if you are an individualist, to destroy a group, because there's nothing more than that. And books and language, these are also all connected to the individuals, and they cannot be separated from each other. When you do that, you are losing the distinctiveness of the crime of genocide. And indeed, scholars like William Shabazz, for instance, in 2010, he was saying that actually there is no distinction anymore between crimes against humanity and genocide in terms of moral distinctiveness of the crimes, because we created the concept of genocide back in the day, because in 1948, crimes against humanity can only be committed during the war times. So during the peacetime, there were no protection for mass civilian populations in a state. So the crime of genocide was needed back in then. But since now the crimes against humanity can be committed during the peacetime, we actually do not need the crime of genocide anymore. Now it has that moral significance. And interestingly, Paul Barnes says the same thing. He was saying that there are two things in genocide: one, stigma, and the other purpose was protection. So there was a huge stigma that stems from Holocaust and the other mass atrocities that feed the concept of genocide, which was this, the stigma inherent to the crime. And the other thing was the protection of the groups. And I must add this as well about stigma. He was talking about that this is an individualized crime because we want to punish a person who can think in this monstrous way. Even if a single individual thinks in this way, intend to destroy a whole group of people, we need to put a particular stigma on that person just because he or she thought in that way. But this kind of approach, an approach that I don't like, because I think it does not reflect the reality, because as far as we can observe, there is some distinct value inherent to the groups, which is noticed by Lemkin as well. But before that, I need to pay a lip service to Larry May, because his account is actually amazing, because he noticed this problem as well. He said that individualism is problematic inherently. He's also an individualist in ontological terms, but he's a neo-nominalist, which he says that we cannot reduce the groups to individuals entirely, but we need to reduce it to individuals in relation, because relations have distinct realities compared to the individuals. And we can explain groups with this individual in relation formula. So being an American is being a particular type of relation to the other people who are defined or define themselves as Americans. And there's a particular form of relationship between Americans, which is, special to them and not to the others. However, my contention to Professor May, if I may, is that this explains, and I agree with that, but this doesn't explain away the distinct reality and distinct emergent properties of the group. So this brings us to Lemkin, and that was a starting point for Lemkin, and that's why I think he's quite important, because he was disturbed from the fact that if you destroy the group as such, it's not just individuals, we are losing something else. But as far as I see, and I know we are tight on time in overall, and I can't go into detail, but maybe I shouldn't, and people can buy the book then. But anyways, so if we are losing something else, but as far as I see, he was struggling in explaining what it is exactly. He was using those realistic approaches on realist ontology of his time, but they were quite essentialists, and they were actually also used by Nazis as well. because they were attributing an essence to the groups. The social ontology or realists of late 19th century were thinking about groups as walks as people came together as a result of some kind of essence, some kind of mystic, togetherness. There's a source of Germanness, there's a source of Turkishness, Americanness. So it's kind of a mystic thing. And we can pick up these lines from Lemkin's reference to Herder, first of all, before anything else. And then he talks about, when he explains groups, he talks about first a common ancestor, then an imagined ancestor. So this is also a kind of, mystic explanation to nations, ethnicity, etc. The other problem with Lemkin's approach is that, and Lemkin, as far as I know, is one of the fathers of the qualitative approach to substantiality requirement, because he was giving a speech to the American Congress, and when he was explaining the term in part, he was saying that, for instance, you can think a group like a house. You don't need to destroy the entire house. You may destroy it under the pillars and house will break down. So he was thinking in this way, but this kind of a functionalist approach is also problematic because, first of all, groups are not this kind of, static entities where we can attribute function to each, member. They are contingent, they're always changing, and they have some functions, but also the function itself changes as well over time. So we are not getting something particular from our groups, from our nationality, from our ethnicity. It changes over time as well. And the meaning of these are change over time as well. So this was, I think, the problem with Lemkin. He singled out the problem because we are losing culture, we are losing language, we are losing a color of humanity, actually, when we lose groups, which is something bigger and different than individuals that forms those groups. But he couldn't, as far as I see at least, he couldn't, position his philosophical perspective with the terms of his time. But now we have the opportunity to do that, I think, because there are new sociological approaches from Delanda, from Simmel, from great scholars like Roy Bohaskar. And we can offer a different kind of sociology, different kind of ontology to the social group, which can also justify the distinctiveness of the crime of genocide. Let me give it back to you, so you can find me more questions about our social ontology.
Well, I'll move a little bit away from that, but I do just really want to acknowledge how important I think that is to talk about kind of the moral, social, and cultural value of these emergent properties of groups, and to be able to have kind of the ontological underpinnings of that, I think is so helpful. And that this is what requires us to see genocide as a distinctive kind of harm, right? That is distinctive from the individual harm that we're imagining in crimes against humanity. Not imagining, it actually exists. And so this critique of Lemkin's more functionalist approach is where I'd like to kind of turn next and talk about, you mentioned this a minute ago. Could you say more about when you claim that groups protected under the definition of genocide are contingent and constantly engaged in the processes of rebecoming? I really loved this part. How does this understanding impact your argument that we should not adopt universal norms, definitive methods for analyzing genocide?
Great. So my criticism towards legalistic approaches now prominent in jurisprudence is that they are both substantialists, which means they're either individualistic or collectivistic, and they're hiding behind legalistic arguments. But when you scrap a bit, you are finding where they're coming from. For instance, about substantiality, I will get back to your question. I'm just giving myself a lead now. So, for instance, if you are an individualist and you are understanding the intended destruction as physical and biological destruction, then your emphasis will be on the quantitative approach, because your thinking about groups is individualistic and you are valuing individuals more than anything. But when you do that, for instance, Srebrenica may not be considered as genocide. Let me give that example, then I will give my critic, because let's consider what happens in Srebrenica. So around that time, as far as I remember, there were 2.5 or 3 million Bosnian Muslims, and 40,000 of them were living in Srebrenica. Actually, it was a protected zone by the UN. And 80,000 military-age male were targeted by the paramilitary forces of Serbia. So now, first of all, which part of the group should be considered as the whole? This is the first problem. First of all, what separates Bosnian Muslims from other Muslims or other Bosnians? Why we should consider that as a distinct whole? This was the first question. Second of it, if genocide is about physical and biological destruction, as the prominent jurisprudence says, then the targeted part should be deemed as 80,000 military-age male. But then whether we should discuss whether this constitutes a substantial part. And ICTY had quite a trouble in claiming that this was a substantial part. Then they said that this 80,000 people, when you targeted this 80,000 people, and when you consider this act in conjunction with the deportation of the rest of the population, which was males under age 16, males older than 40 years old, and all the female population, when you consider these together, you are destroying 2 or 3 generations of men. So biologically, they may be destroyed, but this is also a speculative thing. What are they going to do? They will go and, marry with other, ethnicities. Probably they will go and marry with Bosnian people. And why would, William Shabas was asking that question back in the days, why would the Serbia or Serbian paramilitary forces take all that pain of, transferring 32,000 people while they already killed 8,000, people there? They could have killed all of them and buried them. So if we are, limiting the genocidal intent to the physical and biological destruction, then this formulation doesn't work. What the ICTY did was actually creating a backdoor towards the collective understanding of genocide through substantiality requirement. Because what did they say? Okay, killing 80,000 people in conjunction with the deportations and, destroying this town and considering the political importance of the town, we may consider that Srebrenica may not be recaptured. I don't know what is the relevance recapturing Srebrenica with physical and biological destruction, but Bosnian people would not recapture the city, etc., etc. So actually, Serbian paramilitary forces targeted 40,000 people. So this makes no sense if genocide is all about physical and biological destruction. But as I say, that was a backdoor used by the ICTY. Then they considered 40,000 people as the targeted part. Then they said that they are geographically significant, and they consider the part as substantial. But I think this is quite a problematic approach. So let me rewind the things and answer your question then. When we approach the things in this substantialist way, it is impossible to reflect the reality of genocide, because both the destruction of a group and the group itself is a contingent process. But as lawyers, we need to work with something stable. What we are trying to do is stabilizing everything somehow, abstracting them to a level that we can stabilize them, and then we can work with them. Here is the problem, though. We are working with what we call universals in legal theory. So all the norms that we put are universals, but the situations are particular. So all we try to do with law, or as lawyers, as judges, let's say, that's what judges do. They are trying to apply those universal laws, universal norms to the particular situations. But there's a gap between them, because each particular situation is a novel situation. And in hard cases, they do not fit the universal. And then there is what we call particularity gap, because particular doesn't fit universal. Then you need to work with universal. And this is exactly what ICTY did actually through that backdoor. Obviously, in domestic legal system, this is easier to do. For instance, we are setting a law and we are saying that if you are driving faster than 80 miles per hour in this road, it is illegal. And if you involve in an accident and kill someone, then it is no longer negligence, probably it's advertent negligence or even dolus eventualis. So, it's murder in second or third degree, depending on which legal system you are in. But let's assume a hypothetical example. An elderly citizen who has a driving license, proper driving license, driving an old car, which is also legal. But because the car is old and the driver is also old as well, and his or her reflexes are now slow, even though he or she is slowing, let's say 60 miles per hour on that particular road, if she or he involved in an accident, we may morally say that, okay, this is wrong. She or he shouldn't drive this car in that situation, but law cannot do anything about that. At most, we can say this is, manslaughter, this is negligence. But morally, we are saying that, okay, there's something wrong with it. Either we will change the law, changing the age limit or whatever, or judge will create something by forcing the legal terms. But in domestic systems, this is usually not a big problem. But in genocide, it's a huge problem because the very central terms we are working with are actually so contingent, so processual, it is impossible to stabilize them. So here's my thing. We shouldn't think these terms in substantialist terms because, first of all, race, nationality, religion, ethnicity, these are all terms, ever-changing terms actually, but they're relatively stable. So we think them as if they are stable. So here's my example. For instance, race as we understand it was not existent just a few hundred years ago. In America, for instance, when quote unquote slaves arrived, there were no such racial relationship. But after their arrival and after the relationship has developed, a particular form of relationship, what we call racial relationship, has been developed. Similar things can be said about ethnicity, nationality, except religion. All other three concepts are quite new actually to humanity if we can look at the bigger picture. And the other thing is these concepts are changing. For instance, in America, when we talk about race, it's usually black versus white, right? Obviously, there are other elements as well, but the main element is that. But in another country, race can be formalized in a really different way. So we may persecute people with blue eyes, let's say. Nothing against you, but so we can do that. So what we are doing by circumscribing the concept of race or ethnicity, actually, we are looking the content of each relationship, which is considered as race in the humanity, in the entire world. Then we are trying to abstract these forms of this content of relationships into a particular form, but that form changes over time. So we need to, look into that as well. So when we talk about race, for instance, at that moment, we can define race as a form of relationship, a kind of relationship which is rely on the attributing some significance to the phenotypical differences between two groups of people. So this is a racial relationship, but it may change over time. And also when we abstracted it like that, we can include many different types of relationships under the concept of race. And as I say, it also changes. Ethnicity changes, nation changes. So we cannot define them as set in stone. The second thing is emergence and boundaries of the protected groups. And here comes the egg example, which I know Shannon likes a lot. So we always think things in our life as stable, but actually what is the only thing which is stable is the change itself. Everything changes over time. The only thing is we cannot see things, some things at least, because we are not omnipotent beings. We cannot see that change because we are only living 80, 90 years at most, and some things are have more endurance than us. But that's why I'm giving the example of eggs. So let's say this morning I'm eating an egg and I forgot the egg. I boiled the egg, but I forgot to eat that and left on the table. Then something's happened and I didn't came back to home for 2 weeks, let's say. When I came back, I will find the egg on the table, probably rotten. It will smell terrible, etc. But my mind make the trick and I single out that continuity over time. And despite the change, obvious change on that egg because it's rotten now, I still consider that thing as an egg, but I wouldn't eat it probably if I'm not that hungry, sorry. But when you think it like that, actually what we call an egg is not something exists in a particular time, in a particular form. It's a process. It starts at a particular time and it ends in a particular time. And we can pick different times about when the egg started and when the egg, dissolved or died. But these are all sociological considerations if we go back to the discussions about groups, about collective entities. What I want to single out by that then, when we talk about groups, we are not talking about an essence. We are not talking about something set in stone, something stable. It changes as well. For instance, if Turkish nation, for instance, exists for 300 years now, or at least 300, probably 2,000 years, they claim that, but definitely for 600, 700, 800 years. But if I go back to early 17th or 18th centuries and talk to one of my ancestors, we have nothing in common. Probably I will not understand him or her because although we are both speaking in Turkish, really different dialects, really different terms, terminologies, a way of speaking, but we still consider ourselves as Turkish if we do that ethnically or national, from national perspective. So we are basically singling out that entire process and attributing and meaning to that. And we are constantly, every day we are doing that because we're externalizing Turkishness, Americanness, being a Black, being a whatever. We form those relationships, then we literally forget that they exist because we relate in this way. We attribute something different to them. We imagine that identities, if I refer to Benedict Anderson, but imagining something doesn't make it an imaginary thing. Being an imagined thing and imaginary thing are two different things. You can imagine something, you can externalize it, and then it can have its own properties, just like groups, just like language. I cannot hold any kind of, ownership on Turkish language or English language for you, because it exists beyond us, beyond individuals, in the books, in history, in other form of utterances. So group creates something bigger than itself, basically. So this was the second part. And finally, and that's why we cannot reduce groups to individuals. That's my understanding, but we cannot find an essence as well. So that's what I'm trying to actually say. I hope this was explanatory enough. And
that's great. Thinking about, and I'm so glad that you brought in the egg example, because thinking about the processes, right, and have that just kind of 2-week example, how much can change about, a concrete thing just over the course of 2 weeks, right? I think it's a really helpful visual, even though it is pretty jarring to read. So this next question, I'm hoping that you can say a little bit about the substance and then a little bit more. I want to make sure that we get to some questions about the process of writing this book. So chapter 6 of the book is much shorter than your other chapters, and it serves to synthesize the previous conceptual chapters into your 4-step test for establishing the crime of genocide. And this is something that you want judges to be using instead of, as you spoke about earlier, the kind of problematic way that, for example, the judges were assessing whether or not genocide occurred in Srebrenica. So first, can you explain this test, maybe kind of briefly? And then second, can you explain how you hope this would be literally taken up by judges? So I ask this because academics, we are academics who are working on a really practical issue, right? And we ought to be concerned about how to translate our scholarship into more bite-sized or accessible or just in front of people in order to influence policy and jurisprudence. But I was so interested that this chapter was already kind of more bite-sized than the others. So I'm wondering if this is kind of part of the strategy of presenting it in that way to be able to pull it out and provide it in a different forum.
Well, it was suggested by one of the referees, actually, and it was a good suggestion because I think he really liked this part, and he said, you should make it an distinct part because this is what is valuable about this book. And I'm really glad that you picked on this because apparently we did the right thing. So let me briefly explain what is the test. So first of all, I'm challenging that. My approach in this book, methodologically, I'm starting from a really small doctrinal problem and I'm expanding it to a really large philosophical discussion. And then I'm returning back to the law. So first thing I challenge is that we cannot define genocide as an individualized crime. So this is where I challenge people like Paul Berhans. Because as much as I understand where they are coming from, because they are saying that we are punishing individual to think in this way, there's a sociological part of the issue as well. When we talk about genocide, we are talking about this mass atrocity. So this is not an individualized crime. This is a collective crime. First, we should recognize that, and actually elements of crimes of the Rome Statute kind of try to do that. It was much debated, as you know, addition of an act should be in conjunction with the other similar kind of acts, or that perpetrator should hold a weapon of mass destruction, basically, in order to, commit the crime of genocide. So what I think is, in this test, we should not start from individual. We should start from the collective action. First, we need to look at what I call a normative destructive ethos. So this is a really cool word, I think, but it's a really simple thing. I think genocide is a relationship as well. And what we need to understand from the term to destroy is quite important. I think the term to destroy is not about destroying physically or biologically the group. It's destroying the group's relationships, the relationships that I talked about a moment ago, that historical in-group and out-group relationships that create identity, that create that extra, value that group added to the humanity. So I think genocide itself is a relation. It's a relation between the perpetrator group and the victim group that creates a domination relationship where perpetrators dominate the victim group. And such normative ethos is created with this domination. They started to direct their acts to destroy the essences of that group. However, this doesn't mean that this relationship is a de facto genocidal relationship. I think genocidal intent is something different than the crime of genocide itself. So with genocidal intent, you can commit other crimes like ethnic cleansing, for instance. Intent is the same. So this was the first step. We need to establish this collective relationship. If there's the relationship, then we need to move on whether this process of group destruction, what I call this normative destructive ethos, reached the stage of genocide. So if we think about that, stages of genocide provided by Genocide Watch, we can say that a genocidal relationship constitutes the collective crime of genocide when the acts of genocide in the definition becomes a pattern. So why this is important? Because let's say, God forbid, but you and me and Melanie and we all together committing the crime and we are ethnically cleansing some group. But then I went crazy and killed 2 people. Does this make the entire, endeavor by us, ethnic cleansing a genocide? this is ridiculous because you didn't agree upon that. On the flip side, does it make it genocide for me? I cannot destroy a group by myself. So this is one of the large problems in the jurisprudence, I think, because in continental legal systems, we know that we have a concept which can be translated as incommittable or impossible crime. If you do not have the means to achieve the intended end, this is an impossible crime. And we are, not considering that people or that person committed that crime if he or she doesn't have the means. For instance, I cannot kill you by a piece of paper, probably, if I'm not that capable, at least. So that's an impossible crime. If I try to hit you with that and I say to the judge, oh, I tried to kill Shannon, probably he says, okay, this guy is crazy. Probably we should not, punish him. We should send him to a clinic. So it's same for genocide, I think. I cannot do it by myself. I need a collective assistance unless I have a weapon of mass destruction. If that process reached to the stage of collective genocide, reached to the stage where the acts of genocide are now permanent, now there's a pattern, there's a collective pattern committing that act, now we can consider the entire process as the crime of genocide. Then the third step, assessing substantiality. I know we are lack of time. We have a little time, so let me explain quickly. I think substantiality have two dimensions. One is that genealogical roots, which comes from Holocaust itself. We morally think that if you try to kill a large sum of people, this should be qualified as genocide. So if you are trying to kill 5 million people, this should be considered, at least in terms of genocide law, a substantial part, regardless of any kind of analytical discussion or analytical analysis. But if you are targeting relatively less, people like 8,000, 5,000, 10,000, then we are balancing out. We are looking at the analytical factors, and I gave 3 different analytical factors in the book, which is the geographical specificity of the group, the other sociological special circumstances of the group. Is quite long, so I will not give a justified now explanation to them, but spatial circumstances, sociopolitical circumstances, they should be all considered in order to balance out that genealogical imperative with the analytical imperative. So if there are so many people, it's okay, but if it's getting less, then we need to create new arguments in order to satisfy substantiality. If we do that as well, then it is the crime of genocide at the collective side. Then we can establish the connection with the individuals with the collective side of the crime. So I am basically flipping the entire script. We shouldn't start with individual. It's quite a big suggestion, I know, because lawyers are really convinced that we are dealing with individuals, and the criminal definition is dealing with individuals and individual criminal responsibility. But I think the collective side, contextual side, is inherent to the crime itself, and we should introduce that through the interpretation of the judges.
Thank you. That is so helpful, and I think that's a nice place to kind of wrap things up, is to say the law is not enough, no matter how important lawyers like to think that they are. So I'm going to turn it back to Melanie now, but thank you so much for this conversation. This was really a fantastic event.
Oh, thank you very much.
Thank you so much, both. And Shannon, I like that closing idea that lawyers think the law is important, but not always. Yeah. Thanks so much. I mean, I've enjoyed tonight obviously as an international lawyer as well. So I know we are in the minority amongst genocide scholars. So it's nice occasionally to be able to have a good chat about the specifics of the law. And I hope that with this webinar going online on the IAGS YouTube channel, that it will be accessible not only to members of IAGS, but also to the broader international criminal law community who'll be able to watch this. Thank you both to Shannon and Onur for your time and this webinar. It's been great to hear a lot more about Onur's new book, and I hope that it has piqued the interest of everyone here. For our upcoming webinars, we do have some more coming up in the future. So keep your eye on the events page on the IAGS website, genocidescholars.org, and that's where we will post any information about forthcoming book launch webinars. And we look forward to seeing you at those. And thank you for everyone for attending this evening or this morning or tonight. See you next time.